Dalitso Banda. Dalitso is the principal at Bennett Co.
Thank you, Bill, and thank you, PayDirt, for the opportunity to speak about something that is quite important and personal for a lot of us, particularly of African heritage. Start with a disclaimer. My discussion today is about ESG, particularly the emergence of ESG litigation. Well, ESG litigation goes to the heart of a company's purpose, reputation, values, and approach to risk management. ESG litigation can be an existential threat to companies. It involves more than just monetary compensation, but can also involve forcing companies to change their behaviors. In this presentation, I'd like to provide an overview of what ESG will mean for directors of companies operating in Africa in terms of discharging their existing legal obligations. Also talk about some examples of what you might describe as poor ESG cases and some practical tips as well. So what does ESG mean? Obviously, a lot has been said about it, and we've heard from some of the presenters as to what they are doing in the ESG space. But I thought I'd start not by giving you a technical definition, but simply quoting what Ross Beatty, the chairman of Pan American Silver, said at the AME Roundup in Vancouver earlier this year. And I thought his quote, his statement was quite instructive. It provides the essence of what ESG means. And he said, "It is just critical. At every single meeting I have with investors, it's a number one topic on their list. ESG and social license are buzzwords for being a good corporate citizen. All they mean is doing the right thing. It's not rocket science. It means looking after your workers. It means making sure they go home every day healthy. It means looking after your communities. And it means looking after the countries you work in. It means working with governments, paying responsible amounts of taxes and royalties." End of quote. At its heart, for me, I believe ESG simply means a company being relevant and having a positive impact on the people and the community in which it operates. Why is ESG important? There are a number of reasons why it's important, but I think ultimately it comes down to the positive impact that ESG can have on businesses and on the durability of investments. Companies should strive to have a double bottom line, a financial bottom line and a social bottom line. Typically, ESG matters or ESG events can have significant reputational damage to a business. ESG litigation can result in significant loss to a company. It can be in the form of fines, compensation, and expenses dealing with the claim. It can also be an indication of the failure of a company in its corporate governance. Recent studies have shown that businesses with strong performance on sustainability factors financially outperform businesses with poor sustainability practices. For example, NASDAQ recently conducted a survey of its S&P 500 companies, and they found that over the last 5 years, companies which were considered to be leaders in sustainability consistently outperformed other companies in terms of returns and less risk. Rating agencies as well are also developing methods to develop ESG credit factors, and they're developing credit scores typically through issuing of surveys, collecting data, and looking at publicly available information about companies. This has resulted in some cases. For example, there was a case in Germany where a company had received requests for a survey from a credit agency, which they didn't respond to, and they received a negative ESG rating. and that caused a dispute. Of course, asset owners and managers are increasingly subscribing to responsible investment practices. So, for example, the Principles for Responsible Investments, which has over 3,750 signatories and $140 million under either under ownership or management, are increasingly looking at ways in which companies are factoring in ESG practices in the decision making. And of course, for financing purposes, the Equator Principles provide for a framework to identify and assess ESG risks. Typical sources of conflict, communities, government, companies, investors, rating agencies, as I just alluded to, non-government organizations. I wanted to touch on the legal position in Australia. Essentially, under the Corporations Act, boards of companies operating in Africa but listed here need to consider how they discharge their duty of care and diligence with respect to ESG issues. Under Section 180 of the Corporations Act, boards and directors have a duty to ensure that they do not cause injury to the company where the risk of that injury is reasonably foreseeable. In general terms, this means directors must obtain knowledge about the risks to their business and potential impact of those risks and implement strategies to monitor and manage those risks and exercise proper oversight. There's also obligations, reporting obligations, and this is where the increased vulnerability for companies will come from, at least initially. ESG-related disclosures will likely trigger substantial claims based on public reporting or an absence of public reporting. As companies continue to commit to ESG standards and performance, disclosures will be critical. For example, we've seen in the USA, UK, and the EU that regulations have been introduced dealing with specific ESG disclosures. In the United States, the SEC has established a climate and ESG task force to focus on disclosure and compliance related to ESG. And in the EU, there's been two new significant regulations which also deal with ESG, in particular disclosure of ESG-related matters, the reporting, and also auditing. In Australia, representations about ESG commitments and activities pose a serious litigation risk. Existing laws prohibit misleading and deceptive conduct through financial statements and disclosures, where false or misleading statements are made about risks and activities. Further, the existing laws under the Corporations Act require disclosure in relation to ESG risks where they're material to shareholders to make an informed assessment about operational and financial prospects of the company. Just wanted to touch on some examples. The first one is a bit personal for me. I'm originally from Zambia, and it involves a company where I grew up, essentially, before I came to Australia many, many years ago. It concerns the Vedanta dispute, which some of you may be familiar with. Essentially, 300 residents in Chingola, which is on the Copper Belt, have brought proceedings in the United Kingdom against Vedanta, which is the parent company of Konkola Copper Mines, a Zambian subsidiary. Konkola Copper Mines, or KCM, operates in Changa Copper Mine, which is the second largest open pit mine. The plaintiffs essentially claimed that KCM had polluted the waterways from waste discharge, causing personal injury, and as well as damage to property and loss of income. The essence of the claim really was that because Vedanta, through public disclosures, claimed that it had a high level of supervision and control of the activities within its group, including Changa Copper Mine, it had sufficient knowledge of the propensity of the mine to cause pollution in the waterways. And they argue that this has led to, has given rise to a duty of care to the residents. Now, this is obviously being litigated in the United Kingdom, and there's been an increase in these sorts of claims being brought in jurisdictions where the ultimate parent company resides. Another recent example is the BHP decision handed down by the Supreme Court of the United Kingdom a couple of months ago, again arising from the disaster in Brazil. Essentially, in order to prove their case, the claimants essentially relied on the public disclosures, and this is where the serious risk for companies lies. So they looked at the disclosures that Vendata had made about KCM, and they relied on that as a basis to bring a claim in the United Kingdom. There was some other political issues with KCM, but ultimately there was an application made by the Zambian government to appoint a provisional liquidator, and that provisional liquidator is in charge of the mine. Whether or not Vendata is right or wrong in relation to that matter, which is now before arbitration, the point is there were social license issues which they managed to in which the local community felt that they were not discharging. There was a sense that they're not giving back to the community. And when Vendata lost its business, no one was really fighting back for them. Another example, not in Africa, but I think quite relevant for potential ESG litigation, is a case coming out of the United States a number of years ago. Again, this is a case which was started by some investors in relation to INRI Massey, which owned a coal mine. Essentially, the company had a mining accident. 2 people died. They then went on to make claims that they put mining safety first, and they say that in the public disclosures and also filed with the SEC that they had initiated safety improvements. Subsequently, there was another accident, 29 people died. Investors brought claims against Massey. And of course, because it was a major ESG event, the market cap reduced by $3 billion. And eventually the investors in Massey settled for $265 million. So this is an example of a case which caused significant financial loss to the company because of claims that have been made in public disclosures. The next thing I want to talk about are what we can learn from some of these companies that have experienced high ESG events. So a good example is Rio Tinto. We all know what happened with Rio Tinto, but if you look at if you compare the 2019 and 2020 annual reports, initially in the 2019 annual report, they classified ESG as an emerging risk. 2020 principal risk, it was referred to 84 times. ESG is referred to 84 times in the 2020 annual report, whereas only 6 times in 2019 annual report. Another example is Vale, which had significant reputational issues from the 2 dam collapses. Vale is interesting because, and I thought I'd just share this with you, this is what they put in their annual report this year in terms of what they're doing to deal with ESG risks. So it's an example of them identifying the ESG gaps, making commitments in terms of, in a clear way, in terms of what they're going to be doing, and also providing evidence for what they're doing. Ultimately, in terms of risk mitigation strategies for companies, companies need to build knowledge around ESG risks and integrate those risk factors in decision making. You need to set achievable goals. You need to focus on public disclosures, treat public disclosures like financial disclosures, including adapting similar processes as you would with your financial disclosures. Examine your corporate arrangements, identify any risks within your subsidiaries or affiliate companies, establish plans to deal with those risks and exercise oversight, and ultimately think creatively. A good example that I saw just today, the walkabout example of creating trusts for local communities, is a good way of providing back to the community. I think that's probably about it.